We are counting down the 10 biggest outboard law changes every boat owner needs to know after a recent court shakeup. From stricter inspection records and tougher dealer responsibilities to dramatic updates in safety, warranty, and emissions rules, these new regulations will change how you buy, maintain, and even sell your outboard. Some entries could mean hefty penalties, or they could protect you from hidden risks. Which rule tops them all? Let us begin with number 10. A new era of outboard ownership begins with inspection data transparency. Every certified inspection now generates an electronic report that is uploaded directly to a national registry. Inspectors must sign those reports using digital cryptography, making each entry tamper-evident and traceable. Buyers and insurers can search the registry by serial number and instantly reveal an engine's inspection history, no more relying on handwritten checklists or missing paperwork. This system responds to years of court-documented fraud, where falsified paper records allowed unsafe engines to pass undetected from one owner to the next. The upload mandate covers all engines subject to federal inspection, and penalties for falsification include steep fines and possible license suspension. For the first time, a prospective buyer can verify when and how an engine was last checked and whether any defects were overlooked or hidden. The registry forms the backbone for other new protections, establishing a public record that deters fraud and builds trust in every transaction. With transparency now codified, the days of invisible inspection histories are over. Dealers now face a new level of accountability. Under expanded liability rules, service shops are held directly responsible for missing electronic faults during diagnostics. There is no more plausible deniability when a hidden error code goes unaddressed. The November ruling also put dealer insurance policies under scrutiny, and many states raised the minimum coverage required to operate. For small shops, this means higher premiums and stricter underwriting, especially if they service engines with complex electronic control units. Insurers are now demanding proof that dealerships use accredited diagnostic equipment, not just basic tools. Accreditation must be renewed annually, and records are subject to audit. Failure to maintain certified systems or to spot faults recorded in an engine's electronic control unit can result in civil penalties, denied claims, and even license suspension. For owners, the cost of these changes is often passed along as higher service fees or surcharges on warranty work. The push for better diagnostics and stronger insurance coverage aims to reduce the number of unresolved defects slipping through the system. But it also raises the bar for what qualifies as a trustworthy outboard service provider. Expect to see more paperwork, more certifications, and a clearer line of responsibility when something goes wrong. Dealers are now bound by law to report every confirmed safety defect in an outboard engine to a national registry and to complete repairs before returning the engine to its owner. This duty is mandatory. This duty applies whether the defect is found during a scheduled service, a pre-sale inspection, or a warranty claim. The law gives dealers just 10 business days to log each defect, entering details like the affected component, the date discovered, and the repair steps taken. Once a defect is registered, the system issues a unique defect ticket number, creating a digital trail that owners can access at any time. Only after the repair is documented in the registry can the engine be released back to the customer. The penalty for missing a report or failing to repair is steep. Fines can reach $10,000 for a first offense, with higher amounts and license suspension for repeated violations. In cases of deliberate concealment, criminal charges may follow. Trade association memos revealed some dealers had previously delayed or withheld repairs to avoid costs or bad publicity, but the new law removes that option entirely. For owners, this means every safety fix is now tracked and verifiable, closing the loophole that once let dangerous engines slip through the cracks. The registry's ticket system also forms the basis for future warranty enforcement, ensuring that no defect goes unaddressed or undocumented. Warranty paperwork for outboard engines now draws a sharp line between mechanical coverage and electronic protections. After years of owners being denied repairs for digital failures, the law requires manufacturers to spell out separate warranty terms for engine control units, sensors, and onboard electronics. The new contracts must list covered components, describe the exact process for filing a claim, and limit the grounds for denial to only those proven by clear diagnostic data. If a fault triggers a warning light or an error code, owners have the right to demand a standardized diagnostic report. No more vague explanations or shift in blame. Arbitration rules have also changed. Once a claim is opened, the manufacturer has just 15 business days to resolve it or provide a written explanation subject to third-party review. If a dispute reaches arbitration, the timeline is capped at 45 days from the original claim. These reforms followed court evidence that manufacturers were dismissing valid engine control unit failures as routine wear or owner misuse, leaving boaters stranded and out of pocket. Now, every electronics warranty must be registered at the time of sale, and dealers are required to explain the updated terms before delivery. Owners who experience digital faults should document error codes and service logs, creating a clear path to repair or replacement. The new framework closes loopholes that once left electronic failures in a gray area, giving boaters real confidence that their outboard's most complex systems are finally protected under the law. A single missed step during transport can now void insurance or trigger a fire investigation. The new towing and transport rules, introduced after the November ruling, require that any outboard-powered boat moved on public roads or between marinas must follow certified protocols. No exceptions for short hauls or private trailers. Every transporter, including owners moving their own vessels, must use a pre-trip checklist that covers securement points, tie-down ratings, and most critically, fuel system isolation. Fuel lines must be clamped or disconnected before transit, and outboards must be locked in the upright position to prevent leaks or vapor lock. These changes follow a string of court-cited incidents in which improperly secured engines or open fuel systems led to fires, some resulting in total losses and denied insurance claims. The law also mandates that any transport-related incident, no matter how minor, be reported within 48 hours to both insurers and the National Registry. Certified transporters are now required for commercial moves, and their credentials must be listed on every bill of lading. For owners, the risk is clear. Failure to follow the checklist or use a certified service can mean denied coverage if a fire or accident occurs en route. The new protocols aim to eliminate preventable transit hazards, shifting responsibility squarely onto those who move outboard-equipped boats, whether for service, storage, or sale. Restrictions on legacy. Two-stroke outboards now reach further than ever before. In response to mounting EPA pressure and evidence presented in court, federal regulators have targeted the engines most associated with high emissions, older carbureted and oil-injected models. A growing list of waterways, including several in California, New York, and Florida, now prohibit the use of non-compliant two-strokes during peak season. Owners planning to sell or transfer these engines must submit them for a certified emissions test. Only engines passing this test can be legally resold, and the results are logged in a searchable state database. For many, the test is a formality. Outdated engines rarely meet the current standards, especially if they lack direct fuel injection. Failing units are flagged for retrofit or eligible for state-funded buyback programs, with deadlines for compliance set by each jurisdiction. The new rules also close a common loophole. Private sales between individuals are no longer exempt from emissions checks. If an owner tries to skirt the process, enforcement agencies can void the transfer and issue fines. The court ruling frames these emissions failures as a direct safety risk, citing studies linking exhaust exposure to higher accident rates among boaters. For boaters who rely on vintage equipment, the message is clear. Continued use comes with strict limits, and resale now depends on documented environmental compliance. These requirements lay the groundwork for the next wave of hardware safety upgrades, as regulators turn their focus to the materials and systems most likely to cause harm. A fresh set of deadlines now looms over every outboard owner. Regulators have issued a fuel line retrofit mandate after a court review of fire investigations and technical reports that linked outdated fuel hoses to a string of catastrophic engine fires. The new law targets engines built before 2020, especially those using rubber lines that are prone to vapor lock and fuel seepage when exposed to heat. Owners must replace those legacy hoses with vapor-resistant composite lines certified to meet the latest ASTM F2797 material standards. Compliance is not optional. Engines within the affected serial number ranges must be retrofitted by July 1st. A national approved parts list is now published online, and only components on that list will pass inspection. Once a retrofit is complete, owners receive a digital certificate uploaded to the same registry that tracks defect repairs. That certificate is now required for insurance renewals and for resale, closing the door on undocumented upgrades. To offset costs, a federal rebate program offers partial reimbursement for early compliance, but funding is limited and issued on a first-come, first-served basis. Experts warn that delaying the retrofit increases the risk of both fire and denied coverage in the event of an incident. The new standards respond to years of evidence. Vapor lock and fuel leaks are no longer treated as rare accidents, but as preventable hazards with a clear technical fix. For owners, the message is blunt. Replace the lines, certify the upgrade, or risk losing both coverage and resale value. Every outboard sale now hinges on a single document, the Recall History Certificate. Sellers, whether private owners or licensed dealers, must provide a signed certificate disclosing every recall issued for the engine and proof that repairs have been completed or are scheduled. The certificate lists the engine's serial number, recall campaign numbers, dates of service, and the name of the technician responsible for the fix. If a recall is still pending, the certificate must note the outstanding repair and include the manufacturer's estimated completion date. Buyers have the right to rescind a sale if the certificate is missing, incomplete, or shown to be falsified. In those cases, the law allows buyers to demand escrow of sale proceeds until all recall work is finished and properly documented. This requirement comes in direct response to court findings that for years, recall notices were quietly withheld by some dealers and even manufacturers. Investigators uncovered internal emails and service logs confirming that engines with unresolved safety defects were routinely sold without disclosure, leaving new owners exposed to hidden risks. Now, the penalties for failing to provide a valid recall history are severe. Civil fines starting at $5,000 per violation, escalating for repeat offenders. In disputed transactions, courts can order the return of both the engine and the purchase price, plus damages for any loss caused by an undisclosed defect. The recall certificate must be signed in ink or signed with a verified electronic signature for digital transfers. State agencies maintain a searchable registry of all certificates issued, allowing future buyers, insurers, and auditors to verify authenticity. This paper trail closes a loophole that once allowed dangerous engines to circulate undetected and sets a new standard for transparency at the point of sale. For buyers, it means no more guessing about past defects or unfinished repairs. For sellers, the message is clear. Document every recall or risk losing the sale, and much more. Every owner of an outboard engine rated above 150 horsepower now faces a non-negotiable requirement: a certified safety inspection every year without exception. This rule stems from years of court evidence showing how undetected failures, some with fatal consequences, slipped past casual or unqualified checks. The inspection is no longer a formality. Only technicians who have completed federal certification can issue the official certificate, and each certificate is valid for 12 months from the inspection date. Lapsed certificates mean immediate exposure to fines, insurance denials, and in some cases avoided warranty if an incident occurs. The inspection itself runs through a standardized checklist: fuel system integrity, ignition safety, coolant performance, and compliance with emission standards. Inspectors must confirm that all required retrofits have been completed and that no new error codes are present in the engine's electronic log. The courts heard expert testimony about engines that passed visual checks but harbored hidden faults that only a certified diagnostic scan could reveal. Shops are already feeling the strain. With every eligible outboard requiring a slot, service calendars are booked out months in advance, and owners who wait until peak season risk missing the deadline. Some shops have increased their rates to cover the extra workload and liability, while others have stopped servicing engines they cannot inspect to federal standards. The certificate is now a living document. It must be presented at every sale, insurance renewal, and warranty claim. Any attempt to falsify or backdate an inspection opens the door to civil penalties and possible license suspension for the shop involved. For boaters, the message is clear. Schedule your annual inspection well ahead of the expiration date, keep the certificate on file, and ensure that every finding, especially electronic faults, is logged and addressed. The new law leaves little room for oversight or delay, turning preventive maintenance from a good idea into a legal obligation. A single document can no longer hide the truth about an outboard's past. From November onward, every resale or title transfer demands the complete electronic engine log, direct from the ECU, covering every hour run, every error code triggered, and every system warning ever recorded. Sellers must export the full diagnostic history using tamper-evident software, then upload it to a national database before the sale clears. The law draws a hard line. No log, no legal transfer. Buyers have the right to review the engine's digital footprint before money changes hands, and they may walk away if the log is incomplete or shows signs of tampering. This rule answers years of frustration from boaters who discovered hidden breakdowns only after a deal closed. Court records detail whistleblowers who exposed how some dealers and private sellers wiped or withheld ECU logs to dodge warranty claims or mask recurring failures. In one landmark case, a family's offshore engine failure was traced to 6 prior error codes, none disclosed at sale, and all visible in the sealed ECU history. The court's order now makes such concealment impossible. Any attempt to falsify or withhold logs brings immediate penalties. Sellers face fines starting at $15,000, buyers can rescind the sale and reclaim their money, and regulators can suspend dealer licenses on the spot. The impact is immediate. Engines with clean, transparent logs command higher resale prices, while those with gaps or red flags drop in value. Warranty disputes are easier to resolve. If a defect is logged before transfer, the new owner's claim stands. If not, the manufacturer cannot cite owner misuse without evidence. For the first time, every party in a transaction, buyer, seller, insurer, and manufacturer, sees the same unaltered record, uploaded and time-stamped by the national system. Industry groups protested, warning that public ECU logs could expose proprietary data or confuse buyers with technical jargon. The judge dismissed these objections, writing that the public's right to safety and honest transactions outweighed any claimed trade secrets. The law now treats diagnostic logs like a car's odometer reading, a non-negotiable piece of evidence, critical for trust and market stability. For owners, the message is clear. Before listing an engine, export the full ECU log, upload it to the registry, and provide the buyer with a certified copy. For buyers, verify the log's authenticity and completeness. Any missing data is grounds to halt the deal. With this safeguard in place, hidden histories and warranty denials lose their power. The Outboard's digital memory is now the final word, binding together safety, value, and legal protection for every owner. Across all 10 changes, one pattern stands out. Transparency and accountability are no longer optional for outboard ownership. From recall histories to annual inspections, the law now tracks every vulnerability and demands disclosure. This signals a shift. Boating safety and consumer rights are being rebuilt from the inside out. In today's waters, owning an outboard means navigating a world where every detail matters.